In 2002, I was sentenced to a mandatory life sentence under 18 U.S.C.SS 1959. Is in a one-count indictment. At the time of a crime, I was in juvenile. In 2012, the United States Supreme Court ruled in Miller v. Alabama that it was unconstitutional to subject a juvenile to mandatory life sentence. I filed an appeal which was subsequently granted in my favor based on my mandatory sentence of life. 18 U.S.C.SS 1959 only allows two penalties of life, death or a fine. These are the statutory penalties. Upon me winning my own appeal, I was given a public defender by the name of Catherine Mendez. I specified to her through email and phone calls that there was to be no decision made on my behalf until I returned to Minnesota from U.S.P. Coleman in Florida. Once my travel writ was granted, sometime in August of 2013, there was a status conference held without my presence or consent in the conference. My public defender, Catherine Menendez, made a deal with the prosecutor that I wouldn't challenge my conviction. However, I would have never consented to something so ridiculous since I had already won my own appeal in the 8th Circuit Court of Appeals and the prosecutor conceded to this. This also falls under major inadequate representation. Ultimately, she was removed from representing me after she fed me to the system. My next lawyer would not argue against her coworker. 3 years later, she became a federal judge in 2015 under duress from being held in the Minnesota County Jail for so long. I finally consented to being resentenced. I made multiple objections to being sentenced to a term of years that the statute calls for two penalties, life or death, which are both unconstitutional at this point. In time, all of my objections were denied, and I was unconstitutionally sentenced to 42 years. In 2010, the sentence for murder in the 8th Circuit was just under 250 months, 20 years, and 10 months. I was given double that. 42 years is 504 months. The racial disparities in the juvenile LWOP sentences are stark. 70% of all youth sentenced to the LWOP are children of color, and in the years before Graham and Miller courts sentenced black juvenile offenders to life in prison without parole 10 times more than white offenders. The trend has worsened since Miller v. Alabama. In 2012, 72% of children sentenced to LWOP after Miller were black, compared to 61% children sentenced before Miller. Symptomatic racism and discrimination are added on and being applied. The ACLU of Michigan reports that the average life expectancy of an inmate sentenced to life in prison is 58 years. For an African American, the average life expectancy is 56, and for juvenile sentenced to life, the average is 50.5 years of life. In March of 2016, United States vs. Under Seal 819F. 3D 715 was decided, and it states a district court ordinarily has no discretion to impose a sentence outside the statutory range established by Congress for the offense of conviction. The district court further observed that no authority permitted it to impose a sentence lower than the mandatory minimum provided by the statute. In doing so, it rejected the government's arrangement that SS 1959 could be exercised to permit a sentence of a term of years for a juvenile offender. This shows that the judge manipulated the law to give me 42 years. Following under Seal versus United States Moses Alexis Reyes Canales, U.S. District, Lexus 174108, the district court ruled Reyes Gonzalez is not charged and cannot be charged for murder of a victim. Because he was a juvenile at the time when the murder took place, an individual may not be prosecuted in federal court for crimes committed as a juvenile. If the mandatory maximum penalties for these crimes would be unconstitutional as applied to a juvenile, therefore as the case stands, Reyes Canales is not and cannot be changed in federal courts for murder of victim. I will continue to fight for my freedom and post-sentencing conduct pertaining to myself as I've completed over 60 BOP programs and obtained my GED. This is extraordinary and compelling in itself. My judge says this is unremarkable. Okay, back to part.